I'll have to tell you that story sometime. Yes. Okay. Are we ready? Are we live?
We still, like I said, the attendees are joining.
I see. Okay. 1, 2.
Microphone check. Can you hear me?
You're breaking up.
A little scratchy.
Garbled, yeah.
I'm in a new setup in a new office, so.
Okay.
Victor, do you want us to wait for you while you're reconnecting?
No, I'm fine.
Okay.
Okay.
All right. Well, I think we've probably got as many audience members as we're going to get. If you want to.
Okay. Then the September meeting of the Law Revision Commission is called to order. First item is approval of the minutes.
Move to adopt.
There's a motion.
And
Is there a second?
They're attached to 2021-41, and there are no proposed revisions from the
Okay,
staff.
there's been a motion and a second. Any questions or comments? Seeing and hearing none. Call the roll, please.
Commissioner Carrillo.
Aye.
Chow is not absent. Will not be calling him beyond this. Cubas.
Yes.
Jenkins.
Aye.
King.
Yes.
McAllister.
Aye.
Miller O'Brien.
Aye.
Senator Roth is also missing. Rubin
Yes.
and Simpson.
Aye.
Okay, they're approved. Thank you.
Minutes were approved. Okay, administrative matters. Brian?
Okay, first up is the executive director's report. There are some sort of staffing and resource issues to discuss. One is that Barbara Gall, the chief deputy director, is going to be on a fairly lengthy leave of absence during the next meeting interval, so she will not be present at the October meeting or preparing materials for it. As a consequence, I think that meeting's going to be short. I think this meeting's going to be fairly short as well, but the next one in October, even more so. As we discussed at the last meeting, we have 3 commissioners whose terms are ending on October 1st. That's Commissioner Cubas, Miller O'Brien, and Rubin. By law, they can hold over for 60 days or until their replacements are appointed. So even if your term is not renewed, either because you don't apply for it to be renewed or the governor decides otherwise, you could still attend the next 2 meetings, October and November, unless, of course, your replacement is appointed before that. I think I mentioned at the last meeting, we had hired an office technician, and it was very nice to have a second set of hands on administrative tasks. But consistent with a lot of the sort of oddness around people's employment experiences during COVID, he resigned from his position like about a week and a half into it. His last day is next Tuesday. He gave us 2 days notice. So we're getting about 3.5 weeks worth of work out of him, and we're maximizing that. But we're going to be going back to reposting the position and re-recruiting. So, and we're back to having just Deborah for administrative tasks.
Okay.
I don't know if I mentioned last time, but we were subject of 2 different audits that had just rolled around in the ordinary course of administrative audits. Our procurement practices were audited, and that audit is complete except for the formalization. So we've had our exit interview. We're waiting for a written report. There won't be anything surprising in it. We did well. There were a couple of requirements that we were off on, but they'll be easily remedied. So that one's done, effective. We're also being audited on our personnel practices. It's really bad timing for all of this stuff because with the office having been closed for the last year, you know, there's sort of a extra difficulty in crossing T's and dotting I's. And I think we'll probably have a few points where we were less than perfect on the personnel practices, but I compiled all the materials and sent it to them a couple of weeks ago. That consumed 1 or 2 weeks of my time full time just pulling the materials together. And so they have it, and we're waiting for them to talk to us about their findings. So it's still in progress, but the lion's share of the work for my staff is over. So things should be loosening up a little bit now. This meeting interview and our interval and the next one, we've just been running on fumes. So like I said, the meeting is likely to be short today. It's likely to be short in October.
Brian, remind me who conducted the audit? This wasn't by the state auditor, was it?
No, State
Okay.
Personnel Board.
Oh, okay, got it. Thank you.
So, you know, the audit from the procurement one is Department of General Services, because
Okay.
they're in charge of authorizing delegations
Got
for purchasing
Okay.
authority.
Thank you.
Their audit will be on their website. I assume SPB's will be on their website, but there's nothing going to the governor or higher profile than that.
Okay.
And then the one point that we've been discussing is the rules for meeting by teleconferencing, as we're doing right now. And been watching out for the governor's proposed trailer bill. Still have not seen that enacted. However, a bill was amended in September to address the issue, AB 361 Revus, and that has been signed by the governor. It's an urgency bill. It's gone into effect. It's law now. It effectively waives all of the problematic elements of the existing open meeting law that make it difficult or impossible to meet entirely by teleconference. So those requirements are all suspended. However, the bill sunsets on 1/31/22. So it's going out of it unless the legislature moves really fast next year. These suspensions are only going to be in effect through the end of next January. And then we'll be back in the same boat we were in before, which is we'll have these general obstacles to open meeting teleconferencing. And we'll just have to wait and see. Maybe the governor will put another emergency order into effect, or like I said, the legislature will turn on a dime.
Which they can do pretty easily.
Yeah. So we're good through the end of the year. And the commission had already decided at a prior meeting that it wished to continue with teleconference meetings through the end of the year. So we'll stick to our approved meeting schedule and continue to proceed with Zoom meetings. The last item is that the commission had expressed interest in getting brief updates on the work on the Committee for Revision of the Penal Code, since there are cousins. And they're continuing to hold meetings on about the same pace that we are, and working towards a set of recommendations for next year. This was the first year they had a legislative program, and there are 6 bills that are pending before the governor that came out of the committee's process. All were approved by the legislature, and all are waiting the governor's signature. So pretty good success rate for their first year. And that's all I have to report for the executive director's report.
Okay, thank you. Any commissioner suggestions or observations? Seeing none, hearing none. 2021 legislative program. Brian?
Yeah, thank you. Well, the main memo just provides a status update on the commission's legislative program for this year. And then there is a supplement that Barbara Gall will present that talks specifically about some aspects of the Public Records Act legislation. As the main memo indicates, our program is in good shape. Everything's been approved by the governor.
Not yet.
Excuse me, everything has been approved by the legislature. Sorry. I got tongue-tied because I got news this morning from Senator Roth's office that SB 315 had been approved by the governor. So that's been chapter, or will be chapter. Everything else is on its way to the governor or on his desk. So we're in good shape with the legislature. No reason to think we're going to run into problems with the governor's office, but you never know. So that's all I have to report. There's no decisions required for the main memorandum. I'll turn it over to Barbara to present the supplement.
Okay. Barbara?
Okay, well, there's really not much here, except that the commission has previously approved various changes to the comments for the recodification of the Public Records Act and the conforming revisions for the recodification. And this supplement presents a proposed reports on those comment changes, assuming that the bills are approved by the governor. And so the question for the commission really is, if the bills are approved, are those reports acceptable to the commission to include in its next annual report?
Okay, any comment or question from commission members? Hearing none, seeing none. Is there a motion to approve the proposed report?
So moved.
It's been moved.
Oh, I
and
think Crystal
seconded.
was first.
Crystal was first,
Second.
second, third, fourth. It's been properly moved and seconded. Want to call the roll, please?
Oh, I'm sorry. That's me. Commissioner Carrillo,
Aye.
Commissioner Kubas,
Yes.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Miller O'Brien,
Aye.
Commissioner Rubin,
Aye.
and Commissioner Simpson.
Aye. And the report is approved. Anything else on that one, Barbara?
No, that's it.
Thank you. Item 4, statutes made obsolete by trial court restructuring. Barbara, again.
Yep. Okay, so that's me again. And this memo, and I apologize for not getting it to you sooner in the memo cycle. Like Brian said, we were pretty squeezed this time, but I would have liked to get it to you quicker. But anyway, it presents a draft of a tentative recommendation that would implement the decisions that the commission has made so far in the latest phase of its work on trial court restructuring. And there aren't any particular issues that I had to raise for discussion, except the few technical things in the memo. Is there anything that anybody else wanted to raise with regard to the tentative recommendation?
Any question, comment?
No, I'm looking forward to see what, seeing what types of comments we get. So I'm glad it's out, it's going out.
Yeah.
Okay, and we do have some attendees in the audience.
Yeah.
I guess if anybody has any comments, I don't know if anybody's here on this item, they should raise their hand.
Don't see it.
I don't see it. I guess not.
Okay, so then the question really is, whether to approve this draft as a tentative recommendation to be circulated for comment and posted on the commission's website. And, whether to do that now, whether you would rather wait. And we do have a letter from Mr. Lomax about the jurisdictional classification of civil asset forfeiture proceedings. So my recommendation is to go forward with this now and address the issues raised in his letter later. But we could also, alternatively try to combine everything into a single proposal.
My instinct was the same as yours,
Yeah.
Barbara, that it was a different issue, but comments or questions from commissioners?
I think we proceed.
Yeah, that's my sense as well.
Okay, I guess I need to call the roll on that. And then the question is whether to approve the draft attached to memorandum 2021-43 as a tentative recommendation to be circulated for comment.
Right.
Barbara, do you need guidance on the comment deadline, or are we gonna?
I do. I was going to handle that separately, but we could handle that before we vote. That is with a comment deadline of December 1st,
December 1.
what I would suggest.
Pushing it out further.
So do we have a motion on that?
Is there a motion?
Well, I mean, I think to push it out further than December 1st. What do you guys think?
Other thoughts?
What do we usually do? We're doing what?
This would be, what, about a 60-day
Yeah.
comment period?
I
Is
just
that,
think we're still stuck in kind of COVID craziness. I just think we need to give more time. Maybe
We push it
90
to
days.
January 1st. That means that we're assuming people are going to look at it over the holidays.
Yeah, I think that's a lost month anyway, frankly. I mean. a
So
lot of-
maybe February 1st. Does that seem too long, Barbara?
Pretty long.
I think probably.
What if we split the
December
difference and
1st
make it like middle of December?
I think
Middle
we're
of
trying to
December.
accommodate the meeting schedule.
Are we meeting in December?
Yeah, we have a December 16th meeting.
Oh, so if we make it the 15th, that's right before we meet.
We're
Well,
not
then we
having
wouldn't be
Aaron-
able to get
The comments
any,
though.
any staff comments to prepared and analyzed in time for the meeting.
I mean,
And
like,
then Barbara's gonna be gone for November. I just think, honestly, February is not a bad date. February 1st.
Well, none
It
of
may
this
feel
is,
long, but it's realistic.
none of this is burningly urgent. So if you want a longer period, you can do that. But my sense is that the proposals in the draft have been raised and discussed publicly already, and none of them are really intended to be anything more than technical. Is that correct, Barbara?
Yeah, I mean, we have already tried to alert the key stakeholders to what's been proposed here, and taken some of their views into account in drafting it. So I
Jane?
think that will help it along.
I
Jane?
think we should stick with, yeah, I think we should stick with December 1st. And if there's an indication during this period of time, we're going to have 2 more meetings. I mean, see, 1 more meeting before that. So, no, 2, my brain. Anyway, if it looks like, comments or stakeholders are asking for more time, or there's a lack, then we can always push the deadline back.
Okay.
But if we're that close, it seems to me we're just going to kind of drop the ball. I'd rather see it continue to move forward.
Jane, can I make a suggestion? Can we make it December 3rd? The 1st is a Wednesday, and that's right after the Thanksgiving. So I would give people the full first week after Thanksgiving, and then that gives the staff about a week and a half to process it.
I think that's a great suggestion. I would make a motion to go ahead with this and have it have a comment period that ended December 3rd.
I would second that.
Okay. Why don't we then make that incorporate as part of the original motion about approval of the tentative draft then? So December 3rd, Friday, December 3rd?
Yeah.
Okay.
Okay,
All right. In that case, call Richard.
Who's the maker of the original motion, if that matters?
It does matter.
Do you
okay.
accept the friendly amendment?
Yeah.
Except any friendly amendment.
All right. Very friendly man. Okay. Then go ahead and call the roll, Barbara.
Okay, Commissioner Carrillo,
Aye.
Commissioner Kubas,
Yes.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Miller O'Brien,
Aye.
Commissioner Rubin,
Aye.
Commissioner Simpson.
Aye.
Okay.
All
so
right.
that Takes care of that one.
I was just doing some research on whether proxy voting is permitted, and it generally is not. So you're not allowed to have your dog vote for you.
Well, you can always-
Apologies about that.
Anna, mine is
My vote
snoring. So
is
if you guys hear
yes.
snoring, it is not me.
All right.
My vote is yes on that item.
Okay.
Thank you.
Not ARF, ARF. Okay. Item 5, state and local access to customer information from communication providers. Brian.
Yes. This is another, what is likely to be a quick item because it presents a draft of a tentative recommendation that is based on implementing commission decisions. And the explanatory narrative at the front is recycling of language you've seen before, and the legislation draft was presented at the last meeting. The only significant changes are ones that were approved at the last meeting, and they're enumerated on the first page of the memo. We added some advisory language to the notice to the customer that would be required. We added a provision that requires that when an administrative agency serves as the customer of a communication service provider, that they also have to serve proof of notice on the service provider to establish that they did it, and also to set the date for the 10-day period to run, during which the customer can move to quash or modify the subpoena. And I did a little research into a question that was raised about whether or not service providers could circumvent the delay period of this law through voluntary disclosure. And it looks to me like that issue has been addressed with sufficient nuance by federal law. The general rule is no voluntary disclosure of customer communication information to the government. There's a series of exceptions that are in the federal statute. Most of those aren't relevant to our situation. They're more operational. But there are a couple of exceptions. One is the disclosure of evidence of child abuse to a specified entity. And the other is disclosure to government to address an imminent threat of serious injury or death. And it strikes me when I was looking at that both of those would fit within the exigency exception to the Fourth Amendment's warrant requirements and makes sense as a matter of policy. So I think the federal backstop takes care of this in an appropriate way. And as discussed at the last meeting, I noted all of that in the report itself and in the comment to the proposed section. So those are really the only new things in their implementation of decisions that were made at the last meeting. So the question is whether you have any concerns about the draft or you're ready to approve it as a tentative recommendation for public comment. And then again, there's an issue about how much time to give for comment. And my proposal was even shorter than the one Barbara had suggested. So given the discussion for the last item and the fact that this topic is weightier, more substantive, and probably involves more entities as interested parties, since it would affect any state administrative entity that has enforcement and subpoena powers. It may be that you want to push the comment deadline on that one out further. And again, this whole study we put on the back burner to let existing law settle when Cal ECPA was enacted. And so it's already been sitting for a few years. It could sit a few more weeks if you want to go that way. So first, anyone have any questions or comments about the draft?
About the draft, is it appropriate to see if any of the attendees want to speak to the draft?
Yeah, sure.
So there are 6 or 7 attendees, and if anyone wants to make a comment or raise a question about the draft, do whatever you click to raise your hand, I guess.
Yeah, nothing there.
Seeing none, okay. Is there a motion then to approve the tentative draft?
I make the motion.
Been moved, and is there a second?
Now, I'd like to do the same thing we did last time if possible and consolidate the comment deadline date into the motion through a friendly amendment of Commissioner Rubin's
Okay.
motion. What do you think? I proposed November 19. Again, trying to fit into the schedule to consider it at the December meeting, but maybe Commissioner Miller O'Brien's instincts about February might be good for this one.
I think so, because
Okay.
the trial court restructuring study, it's been around for a while, and this one, we just kind of revived it, and we need to give people time, I think.
Okay.
I
Jane?
think they need more, I think we need more time because I think we're going to have more entities weigh in, as you said, Brian. And I think the virtue of having more time, maybe then we can really wrap it up, which would be great. So February sounds fine to me. I don't know about anybody else.
Any other thoughts? Richard?
No, I don't see any inconsistency in passing these motions as they've been formulated. So I'm perfectly happy with the amendment to my motion.
Okay,
Let's look at February 2022. Oh, we could do Valentine's Day. That would be nice. And that's a Monday.
Look at Jenny.
I won't forget it.
Since I wore pink today, I'll go with it.
comments will be full of love, I can tell, yes.
Yeah, there you go.
Wow.
Good omen. February 14th is a comment deadline.
Sure.
Sounds good.
Any objection? Seeing none, hearing none. So we'll incorporate that as part of the original motion on the tentative draft and Valentine's Day for the end of public comment.
Yeah. And I'll call the roll.
The roll, please.
Commissioner Carrillo,
Aye.
Commissioner Cubas,
Yes.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Miller O'Brien,
Aye.
Commissioner Rubin,
Yes,
Commissioner Simpson.
Aye.
Thank you. That concludes that item.
Okay, and.
Okay, does anyone, but seriously, the Valentine's Day massacre, don't you guys?
That's not what occurs to me first.
Yeah. No, me either.
I'll just, okay.
All right. Last item is Fish and Game Law. Steve,
Good morning, everyone.
morning.
You have two memos before you, 2021-45, which is a public comment memo, and 2021-46, which is just a reference document for the commission identifying past commission decisions in the study. As a brief review for anyone in the audience who is new in this phase of the study, we're considering implementation of technical revisions to the existing Fish and Game Code based on comments that have been submitted by the Fish and Game Commission and the Department of Fish and Wildlife on a previously distributed tentative recommendation. Each month, we've been presenting a set of those comments and staff recommendations on those comments. We've divided them into categories for assistance in the commission's review based on the nature of the comments and on the staff's recommendations regarding the comments. And then we ask for a consent approval of the staff's recommendations as to each category. In the past, we've handled each category individually, first asking if anyone has any questions or comments, and then seeking a roll call vote. But unless anyone has any objection, it seems that there is no reason not to just follow that procedure collectively for all the recommendations in the memo. So I first would ask if anyone has anything that they want to discuss about any item in the memo 2021-45.
Now, any of the commission members? I mean, I thought the wild pigs thing was, potentially kind of a pork barrel issue, but I'll let that- I'll let
How long
that-
did it take for you to come up with that joke?
This is the study that elicits more puns than any
Yes.
other study.
Yeah, I'm thinking.
I find this whole thing to be fishy.
Yeah.
I
Yeah,
was going to ask
Right.
if
I
I
do
was gonna
have,
do some trivia and ask if people wanted to guess the collective nouns for what a group of wild pigs is known as.
I think that's
or
what you should do.
bears
Steve.
or-
I did have a question on one of the items, Steve, in the presumptively approved group.
Okay,
On page 9, the one about must versus shall.
yes.
And I was going to try to look at the context of the code section, and I think there might have been a typo. There is no section 4032 in the Fish and Game Code.
Okay,
Was this the subject, the subject of this code section was about what?
well, let me pull it up here.
Was this the one about hanging on, holding deer's heads after you take a deer?
Let me. I have to pull it up here on my
Okay.
my reference material. I apologize for the
That's
brief
okay.
delay.
Uh, 4302.
Yeah, I
Fourth
might have
deal.
I might have transposed the two
Yeah.
digits. Is
That's
that?
what I,
Yeah, that
Yes,
is about
apologies.
taking deer.
okay, so I read that code section and I don't know why you need to change that to must from shall. And my general I mean, having written hundreds of laws myself, if something is compulsory, it's generally shall, and if it's permissive, it's generally may. So I was curious about why you want, and in that context, I see, David. In that context, I don't know why it needed to be changed to must. So I was curious as to your reasoning, Steve.
Well, okay, so this is embarrassing, and I apologize for this, because the conclusion of the staff, and we talked about it, and the recommendation was to go along with what was there originally, based on consultation with legal writers, et cetera, and talking about sort of trends in writing statutes. There was a suggestion that we go with the word must. That had been the recommendation of the staff in the tentative recommendation. But we actually were persuaded by the comments of the two entities. And the recommendation as printed there's also an error there. The recommendation is to use shall instead of must.
okay.
And I got that backwards as well.
All right.
Again, apologies for this. The recommendation was to agree with the two entities' comments and do the
Okay.
restatement except for that change.
Understood. Okay, David.
Thank you for noting that.
I think that changing it to conform to the entity comments is wrong. It should remain as it's stated. The staff recommendation originally recommended using must instead of shall. That is consistent with both my view, the view of the preeminent authority on legal writing, Brian Garner. It is consistent with the trend in modern statute writing. It is consistent with the trend away from using the inherently ambiguous shall in all legal writing contexts. So I strongly urge the commission to follow the trend, the best advice, and forego using shall wherever possible. Must is far more clear.
The main reason that
Okay.
the main reason that we reversed that recommendation or intended to in the memo is because California's statutory drafting style uses shall.
It's wrong.
Well, it's wrong, but it's consistent. I'm not
We
saying
should keep going in the trend of doing things correctly.
I'm not saying that it's wrong. I'm not sure. I don't have a clear opinion on that, but it is the practice in California's statute style, and even if we were to propose something different, I think it would get changed at the bill drafting stage.
I will also point out that California courts, when they interpret shall, there's any number of California Supreme Court opinions that point out that shall is ambiguous and that it doesn't always mean must. It can and does mean permissive may. So if the point here is to ensure clarity and to make it apparent that you're commanding something, not saying something permissive, then you shouldn't use shall, because it is interpreted as permissive. So if you want to
David,
avoid that,
I would
you
just
have to
say
go with
that
must.
you have a lot of old school judges, and a lot of these laws are interpreted at a smaller court, branch court level, as opposed to the Supreme Court, where they have clerks and other, they have brand new, fresh law students to help support them. Who
So
might
do you
know
think that
what you're
those small
talking
court
about.
judges would be confused by saying must, that they would read that as
work with the small
permissive or
court
ambiguous?
judges, and I can absolutely tell you that they would spend so much time among the judges' chambers trying to figure out why that was changed. I can absolutely tell you that from personal observation. It just doesn't work.
That would be
It doesn't
sad.
go over that smoothly unless we had an executive order saying that from the governor's office, saying we're going to change and update the way that we, and Kara's nodding her head too. Yeah, it's just the way that things are. We move slowly. It's just,
Okay.
it takes a while.
We can be
Sure.
part of the change we want to see in the world.
All right, Jane has her hand up.
I would like to hear from Kara, what she thinks of it. I think I would like to hear her.
I mean, so obviously our office style uses shall. I mean that, and if we were presented with language that said must, we would automatically change it to shall. I mean, that's just sort of our office style. And I'm not saying that it's right or wrong. It's just, we are consistent and that's our practice existing. And like Crystal said, until there's some kind of major movement that we were going to make a change, a wholesale change, I think we would stick with our current practice. Just to avoid confusion.
Right.
Thank you. That's very helpful.
And
I appreciate
regardless of whether, David, whether you see inherent ambiguity.
It's not just me.
No, I know. There is significant clarifying value and consistency. If all the statutes use shall to mean mandatory,
But they don't.
then that, well,
That's what I have a hard time understanding. I've never seen shall to be anything other than must. That means it is compulsory. When something shall be done.
Just one example off the top of my head, Proposition 66, California Supreme Court considered seemingly mandatory language requiring it to complete death penalty opinions within 5 years. It used shall. They interpreted that as permissive.
I have always interpreted it as
crazy.
mandatory, but my concern is, are we going to be doing things and then having Ledge Council have to redo them? Do you know what I mean? This seems like, I hear you, David, and I appreciate your insights on this. I really do. But it just seems like we're going to do a lot of make work for Ledge Council if we start without any kind of other directive along those lines.
I get that, and I will bow to tradition and consistency, but I will point out that if the intent here is to ensure that statutory language is read as mandatory, by using shall, you're opening up to the possibility that courts are going to read it as permissive. And if the intent is to rule that out, then we should be using shall.
I've been listening to this whole discussion and I'm persuaded more by Barbara's position. Jane's position. I understand your point, David, and it's certainly coming from the world of academia. It's an important academic point, but in terms of the real world of getting the trucks moving and the garbage hauled out, I think we need to stick with shall, and I would go with that.
This one's about keeping the deer horns until the inspector shows up to look at them.
In that case, I shall fold my tent.
And just to comment, we're the Law Revision Commission. We have all these strictures on how we're not supposed to set policy and become legislators. And I know this is more semantic than legislation, but I just think in terms of the modest role of what we do, let's just not rock this boat or deer antler, whatever it is.
Okay.
We're going to give a cookie to the worst one.
All right. Okay, so it sounds like there's at least a consensus to stick with what the staff recommendation was intended to say on this one, which is to concur with the two agencies who suggested it stay as shall.
Yes, on page 9, the line should read, I mean, there's many different ways it could read, but probably the easiest is to say the staff recommends using shall instead of must in the restatement.
Okay.
we shall do that.
We shall.
You guys are only proving my point.
Okay. Any other comments or questions or issues from commissioners about the staff recommendations? And Steve, you're intending this to be all three sections. There's
actually 6 different sections, but they're divided according to the nature of the comment and the staff recommendation. But yes, I would be asking about any discussion about any item in the memorandum.
The memo.
And then we'll be calling for asking for a motion to approve all the staff recommendations.
So any other question or comment from commission members? Hearing none, seeing none. Any comment or question from attendees?
There are no hands raised.
I don't see any hands raised. Tick, 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 tick. Hearing none, seeing none. Is there a motion to approve the staff recommendations on the Fish and Game memo?
And again, this would be with the transpose digits reversed.
Right.
So it's 4302 on page 9, and the, as indicated, the staff recommends using shall instead of must.
Make the motion.
All right,
Second
moved by
it.
Richard.
I'll
Is
second
there a
it.
second? Second by Crystal, I think it was. Steve, go ahead and call the roll.
Sure, thank you very much. Commissioner Carrillo,
I think there's enough votes to pass this, so I will register a useless protest vote and say nay.
all right, thank you. Commissioner
Just
Jenkins,
that one issue or the whole memo?
Just on that one issue.
I'm just going down the list here. Commissioner Jenkins,
Aye.
Commissioner Kubas,
Yes.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Miller O'Brien,
Aye, and I'd like to ask that everyone else says aye or nay. No, I'm totally playing.
I like
and,
the.
and Commissioner Rubin.
Aye.
All right. So
And Commissioner Simpson, aye.
Commissioner Simpson, thank you.
I think that's the end of the agenda, ladies and gentlemen.
Yes.
Is there any other thing for the good of the body to discuss or bring up?
No, we did a good job. We got through
Yeah,
so
no,
fast. That's the
good job,
fastest
Ruth, yeah.
meeting, I think.
Yeah.
Well-
Kara, it's nice to see that you survived the end of session.
Yes, my first one. Thank you.
Congratulations, Kara.
Thank you.
Yeah.
And congratulations to Rick and David for your new roles on the commission. Sorry, I missed it.
Thank you. Brian, as long as we have a couple minutes here, do you think it would be worth sniffing around to see if there's any interest in the governor's office in extending past January the ability to keep meeting on Zoom?
I could ask. I have no doubt that they're very well aware of the issue, and we're not the only agency that's
Yeah.
facing this. And
I know they're busy with other things, and I wouldn't want it to fall through the cracks.
I mean, I would probably frame it as a query.
Right.
Just what are their intentions?
Yeah.
Sure.
I suspect that the committee on the penal code has the same issue, because they've been getting huge attendance, and that'll likely drop off if they have to go back to in person.
Yeah.
So, so if somebody like John Burton or Jerry Brown called and said, "What are we doing about this?" That might motivate people.
Yeah.
Great.
Yeah, I'll make the inquiry.
Cool. Okay. Any other comments, issues raised by members?
Well-
Seeing and hearing.
Just want to, I think we're not saying goodbye to anybody yet at this meeting, but I hope that we will see Commissioners Bryan and Miller O'Brien and Rubin and Kubas at the next meeting as
At the
well.
next meeting. Yes.
I hope so too. And if I don't talk to you before you return, Barbara, have the time of your life.
Have a good time, Barbara.
Okay. Thank you all.
All right. we done?
With that, I think we're adjourned.
Okay.
Bye, everyone.
Thanks,
See you
guys.
next
you.
time.
See you in
Bye.
November or October.